The Employment Act of 2007 has a number of opportunities, but also exposures to employers. It's therefore important for employers to consider the various exposures that they have there and see how to mitigate against potential cases that would arise. The first thing that an employer should do to limit its exposure would be to ensure that any person who is coming on board as an employee is properly documented. When I say properly documented, it's not just getting their documents, but also ensuring that they have an employment contract that is in place and that would moderate the relationship between employer and employee. The other thing that an employer should consider is looking at the wage order. The wage order prescribes certain minimum wages that would apply to certain cadres of workers, and in that regard, an employer would be well advised to look at it to ensure that they are not underpaying their workers, otherwise they would run afoul of the law. An employer should also put in place necessary policies. One of the policies that are required under the Employment Act is a sexual harassment policy. If you have more than 20 employees, you would be well advised to have that policy, because without that, you would be infringing provisions of the law. Additionally, the employer would be well advised to have a general manual that would govern matters such as benefits that employees are entitled to, would govern matters of discipline and the process that is followed when a disciplinary matter is being attended to, would cover matters such as expectations of staff in terms of value, matters to do with dress code. It is advisable to have an HR manual that would cover all those matters. It's sometimes called a human resource manual. Other times you'll find wording such as employee handbook that is utilized. Those are some of the key areas that an employer should have put in place or have addressed so as to limit the risks that they might have to employees.